maybe 11:13.
Newton. Newton.
Deputy Newton.
Yes.
November 13th. Okay, so we're gonna have to block. Not block, but we need to watch. Halloween. Check your calendars for 11/13, please, except for Mr. Steele, since he'll be somewhere else.
Oh, what was that date, Judge? Sorry.
13.
It's my birthday.
Okay, never mind.
I'm working on my birthday. I already said so.
November
12?
13th.
Look at the 12th or the 13th.
November. Tell her to sign it. Your Honor, the 13th, we have federal court in Nashville. Knoxville.
12? Or is that your travel day?
Will you be, what time will you be to go there?
Do you see anything that week?
Your Honor, we could do the 10th, that Monday. Oh, that's the,
Well, but
is that Veterans Day?
Let's see.
no, the Veterans Day is the 11th, but the 10th is not good for the court.
I'm not gonna take into account, but if it's just a report.
The report is going to be the 31st, and she said 10 days after. You need time to review the report once it's received. I guess we can argue about it later. Let's get the jury in.
Court back in session.
Would the 12th work? And I'll just handle it since he won't be here. Otherwise, we're on into December.
Oh, no. We're not doing that. I'm fine with the 12th if everybody else is fine.
Good for us, Judge.
Works. So mark both days in your calendar, please. October 31st and November 12th.
No jury in the courtroom.
morning.
Good morning.
Let's get to work. Ladies and gentlemen of the jury, you see yet another packet in your chair that I'm going to read to you. In the criminal court for Shelby County Division 5 of the State of Tennessee versus Brandon Isabelle, indictment number 2203799. Members of the jury, you have now found the defendant guilty beyond a reasonable doubt of first-degree murder as charged in the indictment. It is now your duty to determine within the limits prescribed by law the penalty which shall be imposed as punishment for this offense. Tennessee law provides that a person convicted of first-degree murder shall be punished by imprisonment for life without the possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been raised by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase, or both. The jury is the sole judge of the facts and of the law as it applies to the facts in the case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by the law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the evidence. Victim impact evidence. The prosecution has introduced what is known as victim impact evidence. This evidence has been introduced to show the financial, emotional, psychological, or physical effects of the victim's death on the members of the victim's immediate family. You may consider this evidence in determining an appropriate punishment. However, your consideration must be limited to a rational inquiry into the culpability of the defendant, not an emotional response to the evidence. Victim impact evidence is not the same as an aggravating circumstance. Proof of an adverse impact on the victim's family is not proof of an aggravating circumstance. Introduction of this victim impact evidence in no way relieves the state of its burden to prove beyond a reasonable doubt at least one aggravating circumstance which has been alleged. Statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of statutory aggravating circumstance, which shall be limited to the following. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. Members of the jury, the court has read to you the aggravating circumstances which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence, which shall include, but are not limited to, the following. The defendant has no significant history of prior criminal activity. The defendant acted under extreme duress or under substantial domination of another person, and any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There's no requirement of jury unanimity as to any particular mitigating circumstance, or that you agree on the same mitigating circumstance. Verdict, life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance or circumstances have been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstance or circumstances proven by the state beyond a reasonable doubt and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance or circumstances so found and shall return your verdict upon the enclosed form attached hereto and made a part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. This is where you would list the aggravating circumstance or circumstances so found, which must be limited to those enumerated for your consideration by the court in these instructions. You shall then indicate on the enclosed verdict form, we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without the possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. Take the case, consider all the evidence fairly and impartially. You will complete one of the two forms that I have here if you don't have them. And you will report your verdict to the court. But at this time, the state will make an opening statement.
Your Honor.
Ladies and gentlemen, we've entered the sentencing phase. And what we're talking about is count 2 and count 3, the first-degree murder counts with regards to baby Kennedy Hoyle. The aggravating circumstance that the state is relying on is that the murder was committed against a person less than 12 and that the defendant was 18 years or older. For this phase, and as proof of this aggravating circumstance, the state is relying on the proof that you heard at trial, that Kennedy was born January 31st, 2022, which you saw her certified birth certificate. You heard April Campbell, her grandmother, testify as to when she was born, and you saw text messages between Artisha Stewart and the defendant indicating the time of her birth. And so that's the proof that the state will be relying on to prove Kennedy's age for the aggravating circumstance. As part of that aggravating circumstance, the state also has to prove that the defendant was 18 or older. You heard proof that the defendant's birthday was February 1st of 1997. You heard that proof from the defendant in his statement. He gave his birthday. You also heard Artisha Stewart testify that he was turning 25 or 26 on the day that Kennedy was murdered. And also you have as an exhibit the certified divorce complaint that the defendant filed. It also includes his birthday, February 1st of 1997. That will be the proof that the state relies on to prove that aggravating circumstance beyond a reasonable doubt. Now, once you have listened to the proof, once you've heard any mitigation, the state is confident that you will find that the aggravating circumstance and the nature and circumstances of this case outweigh any mitigation. And we will be asking that you sentence the defendant to life without parole on counts 2 and 3. Thank you.
Well, counts 2 and 3, you've already found Mr. Isabelle guilty. So the state's aggravating circumstance is embodied in that finding of guilt. What we are here today, and this phrase "to decide," is what the punishment should be. Is life enough? 51 years? Or do you have to be, is this man so unable to be rehabilitated that he should be kept in jail the rest of his life? That's what you have to decide. And we'll be showing you evidence that, of course, he's youthful, he's worked, he's got good awards at work. While he's been locked up, he never made bond on this. So he's been in jail. While in jail, he's taken opportunities to better himself, taking classes that they offer there. And that brings our Keisha back into one of the factors is that he acted under the domination of another. And so you'll get to consider that and give it what weight you consider to be proper in deciding whether it should be life or life without parole. Thank you.
Would the state like to call a witness?
Yes, Your Honor. State will call April Campbell.
Ms. Campbell, come forward. Watch your step. Stand right here, face you, and raise your right hand.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Please have a seat. Watch your step.
Good morning, April.
Good morning.
You've been out here all week, haven't you?
Yes.
This is finally your chance, right?
Right.
This is your chance to tell the jury what Kennedy meant to you, what Kennedy meant to your family, and how her loss has impacted you guys, okay? I'm gonna let you go from here.
Kennedy. That was our world. We only got the hour with her. But when she laid on my chest, I got the biggest smile. I got to feed her and change her clothes. But I had to let her go to everybody else. So she just went around the room from me to her sister. Gerard's eyes lit up when she held her. I mean, everybody was in love with her. She was the sweetest thing ever. It's been a long 3.5, almost 4 years. I miss my grandbaby. You know, that was my number 7. She was 7 for me. And she could just take it just like that. It's been plenty of sleepless nights. I ain't slept in 3.5 years. I finally got sleep last night. I mean, you know, we never recovered her body, so when we buried her mom, I had a burial made with a beating heart. It added to her coffin so she would be by herself. I mean, I don't know what else to say. You know, we missed her. And she ain't here now. That's all I can say. That's all I can say.
Thank you. Okay. No other questions, Judge?
Thank you, Ms. Campbell. No questions.
Thank you.
Watch your step.
No, that's all the state proof.
Mr. Massey, Ms. Fuchs, do you have any?
Frankly, I do have proof of it. Call to the stand, Ms. Madison Erwin.
Madison,
Madison Erwin, E-R-W-I-N.
Madison Erwin, thank you,
Ms.
sir.
Irvin, come this way and watch your step. Stand right here, face your honor, raise your right hand.
Do you swear or affirm to tell the truth?
Yes, ma'am.
Please have a seat, watch your step.
Could you state your name and spell it for the court reporter, please?
Madison Erwin, Madison Erwin.
By whom are you employed, Ms. Erwin?
Inquisitor Incorporated.
And did you have a chance to work on the case of Brandon Isabelle?
Yes, sir.
And how old was Brandon when this happened?
He would have, am I allowed to refer back to my notes?
Hearing no objection, go ahead.
Okay. He would have been 24 going on 25.
And did he work? Did he have a work history?
Yes, sir.
And where did he work?
At FedEx.
You know how long he worked there?
Approximately 4 to 5 years.
I have passed you up in your honor for the record of provided the state with the information that's in that for matter moved into evidence. During his work there at FedEx, did he receive any awards or recognitions for outstanding work?
Yes, sir.
What did he receive then?
He received the Purple Passion Award from FedEx. It's a certificate of excellence. He also received Employee of the Year for 2020, as well as a outstanding performance during the fiscal year of 2020 memorandum to the office.
And the letter that was provided to us, is that a letter from FedEx?
Yes, sir.
And would you read that to the jury, please?
Yes.
Relatively short.
Brandon, I truly want to thank you for your outstanding performance during fiscal year 20. Thanks for going above and beyond in all areas. Your positive attitude and great work ethics are appreciated. The extra hours, teamwork, and leadership that you've shown have resulted in overall operational effectiveness. Brandon, you have exemplified what the Purple Promise is about. It is employees such as you that make FedEx one of the most admired companies in the world. In recognition of your outstanding performance, it is with great pleasure that I present you with this Bravo Zulu for making a difference and keeping the Purple Promise. And this is from Jackie Nichols, the Managing Director.
Thank you, Your Honor. And Your Honor, please, I'm going to ask that be made to exhibit the letter and the 2 certificates of excellence.
Collective,
Collected exhibit, please.
you'd like to identify this as collective work achievement? Yes, I will mark it. Thank you.
And during the course of time from the date of arrest to today, Mr. Isabelle's been in jail, have you had the chance to look at his jail records and see if he's completed any programs, has any certificates of completion of programs offered in the jail to better yourself?
Yes, sir.
What certificates of completion does he have?
He completed the electrical basics. He's also completed the master plan, and that's the first one, electrical basics, is from July of 2024. The master plan is from June of 2024. He has completed wellness recovery action plan. This is for reentry. That was completed in December of 2024. And finally, plumbing basics, that was completed in July of 2024.
Your Honor, I'd ask that they made the next cumulative exhibit, please.
For the record, your last exhibit was 195. This will be 196.
during your time of working with Mr. Isabelle, has he been cooperative with you?
Yes, sir.
Also, did your investigation reveal that he has no criminal record, no criminal convictions?
Yes, sir.
Thank you. No other questions?
No cross judge for this witness.
Thank you, you may step down. Mr. Massey and Ms. Fuchs, do you have
No other
anything else?
questions?
Is that it? Go ahead, please.
Thank you. All right, ladies and gentlemen, it's been a long road and we're almost there. The aggravator that we're relying on is that first one that you have in your instructions, that Kennedy Hoyle, the victim, was under 12 years of age, that this defendant was, I'm forgetting the exact language, I think it's over 18 years of age. And we have a couple of exhibits just to show you that we have in fact proven Kennedy's age. Obviously, she was born January 31st. In the very early morning hours, she only lived less than 2 days. Brandon Isabelle, we heard this is a divorce decree that was entered, and it indicates that his birthday was February 1, 1997, which put him at 25 years old exactly at the time of the homicide, the day he murdered Kennedy. We've heard a little mitigation here. Congratulations on the plumbing certificate. Great job being Employee of the Year 2 years before you did this. And the Bravo Zulu. Good job. Those are things that we all do daily in our lives. But they don't in any way mitigate what he did to Kennedy Hoyle. They're not even close. I'm closer to being the starting point guard for the Memphis Grizzlies than those things are to mitigating in any way what he did to Kennedy Hoyle. You look in your instructions and there is a mitigator called, I think it's duress or domination of another. And I want to talk about that one a little bit in relation to the facts and circumstances of what he did to Kennedy. Duress. Was he under duress? Was he under domination of another when he pulled baby Kennedy out of that car after her mother had been murdered? Was he under duress or domination, extreme duress is what it says, or domination of another when he made the choice to throw her in his car and drive all the way 30 minutes to Cordova? Was he under extreme duress and domination of another when he chose to go inside the house and change out of the bloody slides and change out of his clothes and leave baby Kennedy in the car in February while he did that? Was he under extreme duress and domination of another when he made the choice by himself to get back in the car and drive all the way back down to the Mississippi River, to the Wolf River, where it meets the Mississippi River at Mott Island? Was he under extreme duress and domination of another when he drove up and down Island Drive trying to figure out a place to dispose of baby Kennedy? Was he under extreme duress or domination of another when he made the choice to pull her out of her little baby seat? When he made the choice to take her blanket away from her? When he made the choice to take her mittens away from her? When he made the choice to walk down to the edge of the water and throw her in that 40-degree water? Was he under extreme duress and domination of another? Absolutely not. Absolutely not. That is the most premeditated, cold, and calculating act that you could possibly do. I would argue that obviously the aggravators here, the aggravator far outweighs any of this mitigation that they put forward. And that gives you the opportunity to consider life without the possibility of parole. You could still sentence him to life with the possibility of parole. But there are things that we do, there are things that people do in this life that are worthy of not ever being able to walk among the law-abiding, contributing citizens of Shelby County, ladies and gentlemen. This is one of them. This is one of those things. And we urge you to sentence him to life without the possibility of parole. Thank you again, ladies and gentlemen, for your attention.
Go ahead, please.
life is a long time. Sometimes we listen to TV and we listen to stories and we say, oh, they got out. They don't serve in life. They serve life. They served 51 years as Her Honor instructed. 51 years for life. That's a long, long time. Mr. Isabelle would be, what, 76 years old? And you have to understand, too, that what you decide today is whether he gets life without parole or life. But after that, there will be a sentencing hearing where the judge decides how to structure those sentences that are imposed. So those sentences could run what we call wild, consecutively, life plus life, or, and the other offenses
Your Honor,
could, yes.
we have to object to this. It's not
I'll
proper
revoke.
in this setting.
Thank you for moving on, Mr. Massey.
Thank you. And so I think the question is, during that time and prior to that time, has Brandon Isabelle shown you that he has the potential to be a better person? Somebody that you don't have to lock up and throw away a key? That's the question. When we look, it's hard sometimes to think about 50 years and how long ago that was. It was 50 years ago that the Vietnam War ended with the fall of Saigon. I mean, if you don't remember that, I do. It was 50 years ago that President Gerald Ford had 2 assassination attempts. A long time ago. It was 57 years ago that Martin Luther King was assassinated here in Memphis. A long time ago. Has Mr. Isabelle shown you that he's the kind of person who can be rehabilitated by the time he's 76 years old? And when we look, first place we would look is whether he's been a bad guy before. And the answer is no. He has no prior record at all. I respectfully submit that's a heavy weighing factor that you get to decide. Was he hanging on the street corner when he was arrested, or was he working? He'd been working for 5 years at FedEx. And not only that, he was the kind of person that got these awards, that did his job well. He was the kind of person that got Employee of the Year. Not many get that. That's the kind of person Brandon Isabelle was at work. And after he's arrested and put in jail, did he just get sulky? No. He reached out to take programs, to take advantage of the opportunities that are offered to him in the jail to make himself a better person. So that's what you have before you. And is 50 years enough? 51 years. And of course the punishment should not go over into emotion. It should be something that's just. A life sentence, I respectfully submit, is just. And it's no more than necessary to punish this horrible punishment being the person. Thank you.
State gets the last word.
Mr. Massey asked you, is 51 years enough? Is a possibility for Brandon Isabelle walking out of prison one day, is that enough? For the murder of his own 2-day-old daughter, by grabbing her by the leg, throwing her into the Wolf River on a cold, dark, rainy February night. All because she was inconvenient to him. Is 51 years enough? Now, Mr. Massey was talking about duress, domination. What duress? What domination? What proof in all of those exhibits that came forward showed that somebody was controlling him? What proof is there that someone told him, you got to go kill that baby or else? Who made him do this? State submits nobody. This was a choice that Brandon Isabelle made of his own volition when he took that baby from the car. 2-day-old baby Candy. And let's be clear here. We say 2 days old. But she didn't get a full 2 days. She got about 45 hours. He took her and put her in his car and drove around Memphis. Went to Cordova, changed clothes out of those bloody slides. Got back in his car where he left 2-day-old baby Kennedy and drove down to Mud Island, passing every interstate exit, passing all those houses. Got on Mud Island, drove up and down multiple times, past all those houses. There were 100 other things he could have done. He could have dropped that baby off on somebody's doorstep. He could have dropped that baby off at a fire station. But no, he made a choice. He chose to take his 2-day-old daughter. And he showed in his statement what he did. He carried her in his arms from his car down to that riverbank. Her hat already fallen off and hit her head, as he said. Was he worried about that? What did he tell Sergeants Floyd Bush and Boyd? He wasn't. He grabbed her by her leg, threw her into the Wolf River. And what did he say about that? It didn't go as far as the gun. Two-day-old baby Kennedy is forever frozen in time at 2 days old. She'll never have a chance to take her first steps, speak her first words. Never have a chance to go to her first day of school. She'll never learn how to drive a car. Graduate high school. Make the choice of going to college or starting a career. She'll never have a choice to win awards for her work. She'll never have a choice to be Employee of the Year. To get letters of commendation for what she could have contributed to this world. She'll never have a choice to decide whether she wanted to go get an electrical certificate, a plumbing certificate, or whatever it is that she wanted to do in this life. She'll never have a chance to get married, have her own kids, become a grandmother. Is 51 years enough? The state submits that's not. And the state submits that it's proven it's an aggravating factor. She was 2 days old. Brandon Isabelle, on his 25th birthday, took her life. Does the crime of murdering your own 2-day-old daughter by throwing her in the cold, dark, muddy Wolf River on a February night warrant the sentence of life without parole? If not, what does?
That'll be a press one.
Pardon me, ladies and gentlemen, I'll be right with you. I believe that concludes statements and proof
It
from
does,
both
Your
sides. And at this time, I will ask the jurors to return to that very small dining room with yet another folder and spend some time with their thoughts. And report back. It's now 11:11. Is your lunch be served soon?
Excuse.
Recess.
What stands for recess?
Welcome back to Court TV Live. We'll get you back inside of that Tennessee courtroom in just a moment, but we do want to get you an update out of Georgia, where a former trooper was sentenced today to 20 years with time served for the death of 2 teenagers.
A.J. Scott, found guilty earlier this year of driving recklessly back in 2015, causing him to crash into an oncoming car that killed those teenagers and seriously injured 2 others.
And this was someone who was also a mayor of a small town, which they have set a date for their elections that are coming up to get a new mayor. Earlier today, one of the surviving victims gave an emotional victim impact statement. Take a listen.
I cry on Sunday night because of this man right there. He doesn't do anything but smirk at me and smile at me. He doesn't care anything but himself. You put yourself where you're at, and you deserve every bit of it. And you're the biggest liar I've ever met in my life. It changed the whole course of my life. I could never be the same. Ever. It's hard to even eat. It makes me sick to my stomach. And all he had to do was say sorry. All he had to do was say sorry. I guess that's it.
All right, at the end of the day, Scott sentenced to 20 years with time served, meaning he has 10 more years to serve. Of course, we'll keep you updated on any more information. It was a horrible, horrible case all around.
All around. But we are going to get you back to another horrible case, this one out of Tennessee. A convicted killer, Brandon Isabelle. He is going to learn his sentence today.
A jury deliberated just under 2 hours yesterday, finding him guilty in the guilt phase of fatally shooting the mother of his child and then throwing a 2-day-old daughter into the Mississippi River. Let's go back in the courtroom now. State's closing arguments.
Go ahead, please.
Thank you. All right, ladies and gentlemen, it's been a long road and we're almost there. The aggravator that we're relying on is that first one that you have in your instructions, that Kennedy Hoyle, the victim, was under 12 years of age, that this defendant was, forgetting the exact language, I think it's over 18 years of age. We have a couple of exhibits just to show you that we have in fact proven Kennedy's age. Obviously, she was born January 31st. In the very early morning hours, she only lived less than 2 days. Brandon Isabelle, we heard this is a divorce decree that was entered. It indicates that his birthday was February 1, 1997, which put him at 25 years old exactly at the time of the homicide, the day he murdered Kennedy. We've heard a little mitigation here. Congratulations on the plumbing certificate. Great job being Employee of the Year 2 years before you did this. And the Bravo Zulu. Good job. Those are things that we all do daily in our lives, but they don't in any way mitigate what he did to Kennedy Hoyle. They're not even close. I'm closer to being the starting point guard for the Memphis Grizzlies than those things are to mitigating in any way what he did to Kennedy Hoyle. You look in your instructions and there is a mitigator called, I think it's duress or domination of another. And I want to talk about that one a little bit in relation to the facts and circumstances of what he did to Kennedy. Duress. Was he under duress? Was he under domination of another when he pulled baby Kennedy out of that car after her mother had been murdered? Was he under duress or domination, extreme duress is what it says, or domination of another when he made the choice to throw her in his car and drive all the way 30 minutes to Cordova? Was he under extreme duress and domination of another when he chose to go inside the house and change out of the bloody slides and change out of his clothes and leave baby Kennedy in the car in February while he did that? Was he under extreme duress and domination of another when he made the choice by himself to get back in the car and drive all the way back down to the Mississippi River, to the Wolf River, where it meets the Mississippi River at Mud Island? Was he under extreme duress and domination of another when he drove up and down Island Drive trying to figure out a place to dispose of baby Kennedy? Was he under extreme duress or domination of another when he made the choice to pull her out of her little baby seat? When he made the choice to take her blanket away from her? When he made the choice to take her mittens away from her? When he made the choice to walk down to the edge of the water and throw her in that 40-degree water? Was he under extreme duress and domination of another? Absolutely not. Absolutely not. That is the most premeditated, cold, and calculating act that you could possibly do. I would argue that obviously the aggravators here, the aggravator far outweighs any of this mitigation that they put forward. And that gives you the opportunity to consider life without the possibility of parole. You could still sentence him to life with the possibility of parole, but there are things that we do, there are things that people do in this life that are worthy of not ever being able to walk among the law-abiding, contributing citizens of Shelby County, ladies and gentlemen. This is one of them. This is one of those things. And we urge you to sentence him to life without the possibility of parole. Thank you again, ladies and gentlemen, for your attention.
Go ahead, please.
Life is a long time. Sometimes we listen to TV and we listen to stories and we say, oh, they got out. They don't serve in life. They serve life. They served 51 years as Her Honor instructed. 51 years for life. That's a long, long time. Mr. Isabelle would be, what, 76 years old? And you have to understand, too, that what you decide today is whether he gets life without parole or life. But after that, there will be a sentencing hearing where the judge decides how to structure those sentences that are imposed. So those sentences could run what we call wild, consecutively, life plus life, or, and the other offenses could, yes.
We have to object to this.
It's not honorable.
In the setting.
Thank you for moving on, Mr. Massey.
Thank you. And so I think the question is, during that time and prior to that time, has Brandon Isabelle shown you that he has the potential to be a better person? Somebody that you don't have to lock up and throw away a key. That's the question. When we look, it's hard sometimes to think about 50 years and how long ago that was. It was 50 years ago that the Vietnam War ended with the fall of Saigon. I mean, if you don't remember that, I do. It was 50 years ago that President Gerald Ford had 2 assassination attempts. A long time ago. It was 57 years ago that Martin Luther King was assassinated here in Memphis. A long time ago. Has Mr. Isabelle shown you that he's the kind of person who can be rehabilitated? By the time he's 76 years old. And when we look, first place we would look is whether he'd been a bad guy before. And the answer is no. He has no prior record at all. I respectfully submit that's a heavy weighing factor that you get to decide. Was he hanging on the street corner when he was arrested, or was he working? He'd been working for 5 years at FedEx. And not only that, he was the kind of person that got these awards, that did his job well. He was the kind of person that got Employee of the Year. Not many get that. That's the kind of person Brandon Isabelle was at work. And after he's arrested and put in jail, did he just get salty? No. He reached out to take programs to take advantage of the opportunities that are offered to him in the jail to make himself a better person. So that's what you have before you. And it's 50 years enough, 51 years. And of course, the punishment should not go over into emotion. It should be something that's just. A life sentence, I respectfully submit, is just. And it's no more than necessary to punish this horrible punishment of the evil person. Thank you.
State is the last word.
All right, let's bring in our guest. He's in San Francisco, California, criminal defense attorney Joseph Tully. Joseph, it's a tough sell to try to convince a jury that this is anything but the worst case scenario, kills the mother of his child, and then takes this infant and throws, presumably alive, her into the Mississippi River. What's your overall thought here, and in the state of Tennessee, what's going to happen with this jury? And what do you think about the defense attempt to try to maybe switch a juror or two?
So I think you're right. In terms of heinousness, this is one of the most heinous crimes that you can imagine. I did think that the defense did the best job possible given this situation. I think everything about the defense attorney was the best anyone could possibly do. He's not talking a lot of facts. It's not a hard sell. It's very soft, very genteel, very Southern charm, and just kind of quietly reminding the jury that this young man does have good qualities. He is not this entirely pure evil person. He works. He knows the value of work. He's not completely irredeemable. And it's just in a very soft, very Southern way. I think that is the best possible way to get this message across to the jury.
It seems like, because they didn't give a number in opening, that it's just between parole or not parole. What do you think jurors feel? I know you can't say specifically about this jury, but how do they feel about allowing this to basically be in the hands of the parole board of when someone would get freedom, if at all? I mean, there are times when people can get denied parole. This is just an opportunity.
Yes, I do think that the jury looks at things. I think they're going to be very inflamed after the guilt phase, number one. I mean, again, these crimes are very, very heinous. And as to your point, whether or not the jury is calculating, well, if we do give him parole, that doesn't mean that he will get parole. It means it's up to the parole board. And as we know in famous cases, a lot of times people do not get parole. So it's whether or not that's a factor, we haven't heard it argued. I would, honestly flip a coin on that to know if whether or not the jury is calculating, well, we can give this young man a chance, and it's not up to us, it's up to the parole board. The defense could have subtly put that in there. I didn't hear it, but it's a great point.
Yeah, it was very subtle, but they didn't give a number, and it just seemed that they wanted to say, hey, you can lock them up, but don't throw away the key. Joseph Tully, stand by. We're going to get to our break. When we come back, we're going to listen to how the state ends everything with their state rebuttal, and then this will be in the hands of the jury again.
Welcome back to Court TV Live. We were talking earlier about that question in the Florida case with Boileau. We do have the question. We have that 30-minute delay, though, that's imposed in everything except the verdict. So we're almost there. We'll be able to share the question with you. It's interesting. From this jury, they've been at it. But you see the clock is now ticking again.
Right. So we will, again, after we finish up these rebuttal arguments in the Isabelle case, we will get you there. Again, we're in Tennessee, Memphis, where we've been watching the sentencing phase. This is the second part of the Baby in the River murder trial. He's already been convicted. The defendant, again, is Brandon Isabelle.
Jury found Isabelle guilty of all charges yesterday after he killed the mother of his child and then threw their 2-day-old baby into the Mississippi River. All of this was on his 25th birthday. Let's go back into the courtroom now and listen to the closing arguments. This is the state's rebuttal.
Mr. Massey asked you, is 51 years enough? Is a possibility for Brandon Isabelle walking out of prison one day, is that enough? For the murder of his own 2-day-old daughter, by grabbing her by the leg, throwing her into the Wolf River on a cold, dark, rainy February night, all because she was inconvenient to him. Is 51 years enough? Now, Mr. Massey was talking about duress, domination. What duress? What domination? What proof? And all of those exhibits that came forward show that somebody was controlling him. What proof is there that someone told him, you gotta go kill that baby, or else? Who made him do this? State submits nobody. This was a choice that Brandon Isabelle made of his own volition when he took that baby from the car. 2-day-old baby Candy. And let's be clear here. We say 2 days old. But she didn't get a full 2 days. She got about 45 hours. He took her and put her in his car and drove around Memphis. Went to Cordova, changed clothes out of those bloody slides. Got back in his car where he left 2-day-old baby Kennedy. And drove down to Mud Island, passing every interstate exit, passing all those houses. Got on Mud Island, drove up and down multiple times, past all those houses. There were 100 other things he could have done. He could have dropped that baby off on somebody's doorstep. He could have dropped that baby off at a fire station. But no, he made a choice. He chose to take his 2-day-old daughter. And he showed in his statement what he did. He carried her in his arms from his car down to that riverbank. Her hat already fallen off and hit her head, as he said. Was he worried about that? What did he tell Sergeants Wood, Bush, and Boyd? He wasn't. He grabbed her by her leg, threw her into the Wolf River. And what did he say about that? It didn't go as far as the gun. Two-day-old baby Kennedy is forever frozen in time at 2 days old. She'll never have a chance to take her first steps, speak her first words. Never have a chance to go to her first day of school. She'll never learn how to drive a car. graduate high school, make the choice of going to college or starting a career. She'll never have a choice to win awards for her work. She'll never have a choice to be Employee of the Year, to get letters of commendation for what she could have contributed to this world. She'll never have a choice to decide whether she wanted to go get an electrical certificate, a plumbing certificate, or whatever it is that she wanted to do in this life. She'll never have a chance to get married, have her own kids, become a grandmother. Is 51 years enough? The state submits that's not. And the state submits that it's proven it's aggravating factor. She was 2 days old. Brandon Isabelle, on his 25th birthday, took her life. Does the crime of murdering your own 2-day-old daughter by throwing her in the cold, dark, muddy Wolf River on a February night warrant the sentence of life without parole? If not, what does?
Pardon me, ladies and gentlemen, I'll be right.
Okay, wow, that's quite the way to end it.
It is.
Pretty good point. If you're going to come up with scenarios of life without parole.
That seems to fit the bill, especially when so many people were asking, why wasn't this a death penalty case? It's not. Death is not on the table here. And so what we're left with is life with or without parole.
It's going to break. The Isabelle verdict clock is up. The jury has this. This is the penalty phase. Life with or without is the decision they're making. The Florida clock is back ticking. They're back at it after the question. We will watch together the question that the jury had. There was 2 of them in the Boileau case. Stay with us.
My 2 best friends were just murdered.
Join me for a Court TV true crime series where we take you from the crime scene to the courtroom.
Donna Adelson hates every piece of grass that Dan Martell ever walked on.
It's something that'll haunt all of us forever.
It always seemed like he was covering or deceiving.
This was a whole different level.
Victim to Verdict with Ted Rowlands. New episodes Saturday night, 8 Eastern and Pacific.
Only on Court TV.
To Florida we go. The court-imposed delay is up. What's the jury question in Boileau? Let's find out.
So back in the courtroom today, or now, we received a verbal question from the jurors and one of the bailiffs. I asked they reduce it to writing, and it then morphed into a second question. So the first question is, can we have a tape measure? The second question is height of both Paula and Dale. So let's deal with the second one first. How do you all want me to respond to height of both Paula and Dale? I have my notes. I know what the witnesses said.
But the answer is in the evidence.
I think this is one of those general, Your Honor, you have to rely on your memory of the facts and evidence as presented.
I agree.
I will instruct the jury on that they asked this question, that you are to rely upon your memory of the evidence in answering that question.
Yes, Your Honor.
I wouldn't be opposed to telling them that the answer is, it was given. The medical examiner testified.
If you all are in agreement, I am fine telling them that Dr. Rachel Lang testified that Ms. Wright was 5'6" tall, that Mr. Boileau testified that he was 5'6" tall. This way I'm not telling them the answer, I'm telling them what people testified to.
Yeah, I'm fine with that.
I'm fine with that, Your Honor.
All right, regarding the request for a tape measure, only because I had reason recently to look at this, I had some case law kind of squirreled away. There is a case out of Georgia, Collymore versus State, Collymore v. State, Supreme Court of Georgia, found at 782 Southeastern 2nd Reporter 7, 298 Georgia Reporter 335, Supreme Court of Georgia, 2016. It was held to not be error to allow the jury to use a yardstick and ruler over defendant's objection, where there was no argument that they were that the devices were inaccurate. So the yardstick and the ruler did not have the effect of introducing new evidence. They were merely standard measuring devices which allowed jurors to examine evidence, and the accuracy of the devices was never questioned. There's also a Florida Supreme Court case, Gonzalez v. State, 136 Southern 3rd 1125 from 2014, where the Florida Supreme Court held that it was not error to allow the juror to have a magnifying glass in the jury room after they requested one. So with that being said, I have a measuring device that unfolds. It's belonged to my grandfather once upon a time, and it's probably older than everything in this room, but I'm happy to let the jury use it if there's no objection from the state or defense.
No objection from the state, Your Honor.
No objection.
Okay. Folds out to 6 feet. So, very good. All right, we'll go ahead and bring the jury back in.
Okay, Judge, the jury gets their answers, 5-6 for both victim and defendant.
And they get that old school tape measure. I was thinking, okay, they're going to give them one of the utility ones.
Yeah.
No, one I used to see in school long time ago.
Love it. Joseph Tully, your thoughts on what does the question mean and the decision to give an answer? Sometimes the answer is go back and rely on your memory. They're going to get a tape measure or a measuring device.
Correct. So basically, the approach judges always take with responding to specific jury questions is to be very, very reluctant to give them anything. I was surprised here that the response wasn't, you can ask for a witness testimony, you can ask to see evidence in the case. Any readback that you want, let us know, and we'll give you the testimony in readback. Here, both sides agreed to it. To give the answer, and the answer was testified to, so I think the approach is sound. But judges get overturned the most when they do too much in terms of responding to a jury, so that's why they're so reluctant. In terms of what it means, I flip a coin at this point. I couldn't tell you if it's good for the defense or the prosecution,
Yeah, it's
or both?
really unclear.
Who knows?
Really unclear from that question, but they are hard at work. That's what it tells us. Joseph Tully, thanks so much for all of your analysis this hour. Coming up, we are going to not only keep our eye on if there's another question there in the Boileau case, but also the deliberation for the penalty phase in Tennessee versus Isabelle. But next, we're heading to a live trial in Michigan, the home invasion hoax murder trial. Breaking news out of Ocala, Florida. The jury has reached a verdict. This is in the case against a former deputy named Leslie Boileau, who admits to shooting his girlfriend after they had been out drinking. He says it was an accident and he was trying to train her on using a firearm, but the prosecution says this was manslaughter. This jury was out an hour and 33 minutes. About 30 minutes ago, they asked for a tape measure. Now they are coming in with a verdict. Once we have audio inside of that courtroom, we will take you there live, and it looks like they are starting up now.
Yes.
Okay. Mr. Boyle, will you please stand for the reading of the verdict? Madam Clerk.
Verdict, we the jury find as follows as the defendant in this case. The defendant is guilty of manslaughter. Did the state prove beyond a reasonable doubt that during the commission of the offense, the defendant personally carried, displayed, used, threatened to use, or attempted to use a firearm? Yes. So say we all, day this first day of October 2025.
Okay, thank you. You all can be seated. Madam Clerk, will you please poll the jury? Members of the jury, the clerk will ask each of you individually whether this is your verdict. You respond with yes or no.
All right, while they go through the polling of this jury, there you have it, guilty of manslaughter. Fairly quick verdict from this jury. Let's bring in our guest for this hour to discuss, and we'll keep watching what's happening in that courtroom. Alexis Rosenberg is with us, trial attorney there in Sarasota, Florida, not too far from Ocala. Alexis, I was going to ask you if I had a chance before the jury came in with this verdict where you were leaning, but tell me what you think about not only this verdict, but this defendant taking the stand.
Well, I think he needed to take the stand in this case, so I do think strategically that was probably a good call. But, I mean, I'm not surprised by it. I mean, he's using a firearm around his girlfriend. They're intoxicated. I definitely think it raises to that level beyond negligence.
Alexis, we're going to go back in. It looks like they are done polling the jury.
Or no.
Linda Young is a
Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege to not speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to each of you to decide whether to preserve your privacy as a juror. With that said, I hereby discharge you as the jury of this case. I do want to thank you sincerely for the time and attention you gave to this matter. If you'll retire once more to the jury room, Deputy Boucher will hand your cell phones out. I also have some juror certificates I will come back and give you as thanks for your jury service. I'll be with you shortly.
Thank you.
The jury has left the courtroom. Mr. Boyle will be remanded into custody.
The court consider allowing him to remain at liberty pending sentence.
No, sir. Now, let's talk about sentencing. He's entitled to a pre-sentence investigation. So one will be ordered. I would like that back from the Department of Corrections within 30 days. Now, how long? I see a lot of people here. I don't know how many people are going to want to speak at sentencing. How long do you all think we will need for a sentencing hearing?
I would imagine maybe at least an afternoon, Your Honor. If the court would allow, I can also kind of, if your assistant could provide a couple dates outside of that, I can obviously work with what works with the family and kind of have a better idea of how many statements to have a better idea of what time we would need.
Okay. All right, well, as part of the pre-sentence investigation, people are free to write letters.
Yes, sir.
And for the state and the defense. I anticipate that I will probably do more reflecting on what sentence will be imposed than in most cases. I would appreciate as much information as I can have from both the state and the defense with the pre-sentence investigation. I will not send, I want at least 2 weeks after I have the PSI back to reflect on what's in it before we have a hearing.
Yes, sure.
So, an afternoon, how long do you think you would need, Mr. Taddy, for what evidence you expect to present?
Probably a similar amount of time.
Okay. All right, let's do this then. I ordinarily set a sentencing date today, after verdict. I will, Madam Clerk, for calendaring purposes, I'd like to put Mr. Boileau's case on my October, I think, 14th pretrial conference docket. Is that a Tuesday?
It is a Tuesday.
Okay. For calendaring, just so we have another date out in the future, he'll be put on that date. By then, I'll have my assistant reach out to you all with possible dates for sentencing, and we can schedule it accordingly. Do you all think you'll need, between the two of you, a day, or an afternoon each, or you all think an afternoon or a morning total will be sufficient?
I think a day.
Maybe a day, Your Honor, if you want to kind of give us the availability this afternoon, even as soon as that, I can kind of talk to the family, maybe have an idea, so when Ms. Seek reaches out, I can give a better idea.
Okay. Let's do this, Madam Clerk. Let's put him down on my November. Do you have my calendar? November 18th, 1 o'clock for pretrial conference. The PSI should be back by November the 1st. Between now and then, we'll figure out a day. I don't know with my trial schedule where we'll end up. We're probably looking, so that everybody here has an idea, probably mid to late November at the earliest, possibly even into December, but well, I'll try not to put it around the holidays if I can, but.
Sure.
Okay. Very good. All right. Well, I'll see you all back in a couple weeks. Anything else to take up before we adjourn?
Nothing from the state, Your Honor.
No, sir.
Okay. All right, very good. We'll be adjourned.
All right, the judge saying he's going to be looking at this one even more closely than the average case, because we do know here that the max for manslaughter with a firearm is 30 years, but a lot of factors can go into what that minimum is going to be. Let's bring in from Sarasota, Florida, still with us, trial attorney Alexis Rosenberg. I saw a slight nod from him, Alexis. It seemed, I don't know if that was just his natural reaction or if it was almost an acceptance of, I kind of knew this is what was going to happen. Even his attorney just kind of, kind of shrugged a bit when there was the finding of guilty here. But I think a lot of us felt that this was clearly manslaughter.
I think when you have a client, one of the things is prepping them for the worst. You have to tell them so that they're somewhat, as much as you possibly could be, prepared facing the amount of time, 30 years, that he's potentially facing. I don't think it was a surprise. I mean, we have a sheriff, that's trained in gun use who is handling the gun in this manner. It's sad. I don't think, he didn't have the intent to hurt her, and unfortunately, we have someone who is dead.
Yeah, the sheriff's deputy who took the stand, and I got to tell you, Alexis, he sounded like an officer when he took the stand. Not an officer who was involved in something, an officer who would have been telling this jury about an incident that they investigated. You didn't see the emotional connection. I thought I saw him starting to get a bit emotional, trying to hold back perhaps some emotion when the jury was being polled. Let's listen back to him taking the stand in what I think was a pretty problematic part of his testimony when he talked about his intentionality. Let's listen.
When the gun went off, it was in your hands.
It was.
And when the gun went off, you were the one who pulled the trigger.
I was.
And when the gun went off, you were the one who intended to pull the trigger at that point in time.
Yes.
When you were sitting at that table with Paulina, there was a point in time you activated that red dot site.
Yes.
In fact, you told Detective Kernos to show her how that site worked.
Yes.
Show her how to get a site picture.
Yes.
Show her how to aim at a target.
Yes.
You heard the medical examiner's testimony yesterday that when that path of that bullet went directly in her forehead and directly out this back of her head.
Yeah.
Correct? So that means at the time that gun went off, it was aimed directly at her.
That was a cross-examination by the prosecution. They were successful. Alexis, what do you think happens at sentencing in this case?
Well, they're going to go into, obviously, the standard, the mitigating and aggravating factors. I mean, in this case, you have a defendant that doesn't have any previous criminal activity. He actually was a public servant. There's, they probably had a very good relationship overall. And I think that all those factors are going to go into play. Once again, I don't think it was his intent, but this testimony, because it came across so cold, and as you said, his experience and his education testifying was to his detriment here, because it just was like he didn't care. It was, this is what happened.
You know, there was a case in Punta Gorda, Florida, where a woman was killed during an active duty or active shooter training session, where an officer accidentally put live rounds when he was trying to put in blanks to carry out this session with these volunteers, and an elderly woman was killed. He ended up getting probation for that. This defendant, essentially, even though the setting is very different, he says this was a training session and he accidentally had ammunition in his firearm. Do you think with this conviction, though, there's any chance he gets anything that low?
Listen, I don't think this was a training session. This came across to me as, okay, we're bored, we came back from drinking, and, let's play around with this gun. But, but do I think that he's going to walk away with probation? No, I don't think that, because when they made the motion for him to be released, during this duration before his sentencing, the judge quickly denied that. I mean, there wasn't even a pause. So I do think he's going to end up, serving some jail time.
That is telling. You are right. Alexa, stand by. We're going to leave this case here. Leslie Boileau, we're going to know what the sentencing date is soon, and we will, of course, keep everyone updated on what happens going forward. Coming up when we return from this break, we're going to head to Michigan for the home invasion hoax murder trial. 2 men accused of pretending to be utility workers looking for a gas leak to gain entry into a jeweler's home, and the husband of this couple, he died. We'll be right back.
Tonight on Closing Arguments, a family of 4 faces twisted allegations of caging and sexually abusing foster children. We'll bring you takeaways from today's big hearing.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
4 dead students.
None of it seemed to make any sense.
He was evil.
What devastation.
All I could do was scream.
Victim to Verdict with Ted Rollins. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
They came to the door and said that they were DTE employees and that they were checking for a gas leak.
A completely disturbing and unforgivable act, in my opinion.
We're DTE. We're checking for gas leaks.
Mr. Hernandez and Mrs. Zawago came into the house, and my husband was going to show them where the basement was.
When we asked him why only one victim was killed, he became irate and yelled something along the lines of, "What do you mean, why did we kill only one? It wasn't supposed to go down like that."
Turning our attention now to Michigan, where testimony is underway right now for defendants Carlos Hernandez and Joshua Zuazo. Both men are charged with felony murder and 2 counts of unlawful imprisonment, accused of posing as utility workers to gain access to this home of Linda and Hussein Murray, the owner of a jewelry store. Linda was allegedly tied up with duct tape and hit by the defendants. Her husband was taken downstairs into the basement of their home and instructed to open a safe. He said they didn't have a safe. He was hit, and we're going to hear more testimony about his injuries, but he eventually died from those injuries. Before we get you into court, here's an overview of this case. Legal correspondent Kelly Craft has the background.
DTE. We're checking for gas leaks.
The man ringing the doorbell posing as a utility worker is Carlos Hernandez, along with Joshua Zuazo, according to investigators, who say the pair used this hoax to get into the home of Hussein Sam Murray. The next morning, Murray was dead.
He give you anything you ask for. If you didn't have no money for something and you needed it, Sam will help you out.
He was the most generous, kindest man in the world.
He's just an amazing person, kind-hearted.
Sam like my uncle.
Murray owned the Gold and Glitter jewelry shop near Detroit for more than 30 years. Prosecutors say Hernandez and Zuazo allegedly targeted Murray, believing he would have valuables in his home.
He asked me, where is the jewelry and where is the cash?
Murray's wife, Linda, testified at a court hearing that after her husband let Hernandez and Zuazo into their home, the pair asked to be led to the basement on the pretext of checking for a gas leak.
I started asking, where's my husband? Where's my husband? And I didn't get a response. And when Mr. Zuazo came up the stairs, I saw blood on his vest. And I started screaming. And Mr. Hernandez hit me in the face.
The medical examiner testified that Murray had been beaten, stomped, and ultimately choked to death.
He had duct tape around his face, covering his mouth. He had duct tape around his hands and feet, also zip ties around his hands and paper bags covering his hands.
After binding Linda Murray with duct tape and ransacking the home, police say Hernandez and Zuazo fled in her car. Both were arrested within a couple of days and charged with felony murder and unlawful imprisonment.
Not only 2 defendants in this case, 2 separate defense teams, but we also have 2 separate juries, which is unique. Let's go in to hear the first witness of the day in front of these juries, the victim's neighbor.
K-R-I-S-T-I-N-N-A-H-A-S-S.
All right, thank you. And where do you live?
I live at 3759 Newcastle Drive in Rochester.
Okay, and how long have you lived in that subdivision? 11 years? Okay. Do you remember back in October 11th of 24, did you have to talk to the police that day?
I did.
Okay. And do you recall about what time of the day did you have to speak to the police?
Probably around 12:15.
Okay. And what did you talk to the police about?
I told them what I had seen that morning when I had been out for a walk.
Okay. And you went out for a walk that day?
I did.
Okay. And what time did you leave the house to go for a walk?
I left at 11:15 to walk my dogs around the block. Sunny. It was a beautiful day like this week.
Okay, so you left your house about 11:15 to walk the dogs.
I did.
Okay, and while you were out walking with your dogs, did you observe anything that caught your attention?
Yes. The first thing was it was very busy.
It was
Busy.
Okay.
Immediately, the houses, down from me had a lot of action. The dogs were kind of excited about work crews, a lot of trucks, a window crew at another house 3 doors down. So they had the table saw out in the driveway and people working. It was, exciting for them. They were distracted.
The dogs were distracted.
Yes. But almost immediately, I heard a squeaking noise, like a fan belt, of a vehicle that was going so painfully slow. It was kind of annoying, but everything going on, it was maybe 5 miles an hour. And it was, as it passed me, the pickup truck carried on down the street.
Okay, and when you saw this truck, what street were you on in your subdivision?
I was on Newcastle. I was only 2 doors down from my house.
Okay, so you had just started your walk, and and a lot of stuff is going on, but you see a truck.
I heard it first.
You heard the truck first. What type of truck was that?
It was a pickup truck, a white pickup truck.
Anything about that truck that caught your attention besides it going slow and the noise?
Honestly, the noise was obnoxious almost.
Okay, and so when you heard this noise, that truck caught your attention, and what did you do next?
It rolled on, so nothing. I carried on with my walk. Continued maybe another couple houses down. Stopped to let the dogs take a sniff, and then I could hear it coming back up the street, the other direction, toward me.
Okay, so I want to just orientate a little bit. Are you familiar with the Murray's house?
I am.
And do you know where they live?
I do.
Okay, and were you friendly with them?
I was.
Okay, so in relation to where you live and to where the Murray's house is, can you describe to us where that is?
3 doors down on the opposite side of the street from my house.
Okay, so when you left with your dogs that morning to walk, were you heading in that house's direction?
I was headed toward the Murray's house.
Okay, and so you testified that pretty quickly you heard this truck.
I did.
Okay, and when you saw this truck, was it coming from behind you or towards you down the street?
As I left my house to start the walk, the truck came from behind me and passed me down toward the street. It passed me and it passed the Murray's house and it disappeared around the bend.
Okay, and so while you're walking, that truck goes past you in the Murray's house at that time?
It did.
Okay, and about how long after you saw the truck, heard that noise, does that truck come back around?
Within a minute.
Okay, and when that truck comes back around, do you hear it first or do you see it first?
I heard it.
Okay.
And I looked up then to see it.
Okay, and when you looked up to see that truck come back around again, what did you observe it, if anything, of that truck at that time?
The first response was annoyance. Basically, as slow as you could be, almost advertising, hey, I'm casing your street. It felt that way. It would feel that way to most people.
So when you observed that truck, were you concerned at that time, or was
Yes.
it just, okay. Did you see any markings on this truck?
I did look up to confront the driver and initially looked at the face. The window was down and was prepared to just kind of hold my hand up and say, how can I help you?
Okay. Did you do that?
I looked up and I looked at the driver, and at the same time I saw the DTE decal on the side of the truck. It diffused me completely.
So when you saw it may have been utility company, you were no longer concerned?
Yes, it occurred to me that, they're just looking to do service somewhere.
Okay, and at that time you said you were going to stop and confront the driver.
Mm-hmm.
Did you observe anything about that driver at that time?
At that time, not necessarily.
And so after easing your concerns about what you observed about this truck, what did you do next?
I carried on around the block, fairly short block. I was back to my house within 12 minutes, probably, and I went home with the dogs.
Do you recall about 11:15 you left, and it was about a 12-minute walk, you'd say?
Yeah.
Okay. Do you recall how many people were in the truck?
Yes, there were 2 men in the truck.
Okay, 2 men in the truck.
There were.
Okay, and when you see this truck the second time, does it continue driving at the same slow pace, or does it stop, or what does it do?
At the moment that, as I mentioned, that I felt like I was going to intervene, and I saw that they were actually pulling up to the curb. I was taking a picture.
Hitting the pause button on this testimony because we have to slip in a quick break. But before we do that, let's bring in trial attorney Alexis Rosenberg to see if she can give us perhaps some insight into this dual juries. Hate to put you on the spot on this one, Alexis, because I haven't seen this other than the Kristen Smart case out of California, where a father and son were on trial and they had 2 juries. But it seems like these jurors are going to be rotated in and out. What do you think the rationale is for having 2 separate juries when we know we've seen single juries handle double cases when we have multiple defendants?
Well, I think that they're just trying to make sure that if they get a conviction, that it's solid, is the only reason. I mean, one of the things they could have done is they could have bifurcated. That was an option, but a lot of times courts find that to be a waste of the court's time. So keeping them together, since it's going to be the same testimony, and they allegedly did this together at the same time. But I do think it's interesting having those two juries at the same time.
Yeah, and one wasn't present for the other defendant's opening statement, which I found fascinating. But I think you're right. It does save time and money from two separate trials, but they are pointing the finger at each other. So it's likely that they can't just simply have them tried together because they have antagonistic defenses. Alexa, stand by. Let's get to our break. When we come back, we'll have more, picking it up with the victim's neighbor testimony, in this case, out of Michigan. Back to court in just a minute, but first, here's a look at some of the other trials that we've been tracking here at Court TV. In Florida, Leslie Boileau, we just had a verdict in that case. He was found guilty of manslaughter. This is after he took the stand today and admitted to aiming directly at his girlfriend before shooting her between the eyes. A sentencing date has not been set yet. And in Tennessee, a man found guilty of killing his 2-day-old daughter and her mother is being sentenced today. You see the clock in the corner of your screen, an hour and 17 minutes. The jury has been deliberating over that sentence, whether he should get parole. And also in Florida, an Army vet is on trial for fatally shooting his girlfriend and then disposing of her body. But Daniel Stearns says he shot her in self-defense. We'll keep you updated on all of these trials throughout the day. But for now, let's go back to Michigan, the home invasion hoax murder trial. And right now, we are going to go to the testimony. We just heard from a victim's neighbor who said she heard the commotion, but now the wife of this jeweler, the victim in this case, is on the stand. Let's go in together.
And with Golden Glitter, which is the jewelry store, and then on the other side was Hamtramck Pawnbrokers.
Okay, where were they located, those stores?
In Hamtramck.
Okay, and he would go there on a regular basis?
Yes.
Did he have a regular schedule that you were aware of when he'd go and when he'd typically come home?
Yes.
Would he vary that schedule very much, or is he someone who is pretty consistent with his schedule?
Pretty consistent.
Okay, and during the week, Monday through Friday, what times would he approximately leave your residence and then go to those stores?
About 12 noon.
Okay, and what time would he typically return home?
7.
Did he work on the weekend?
Only Saturday.
Okay. What type of car did he drive at the time?
An Audi.
And was it a brand new one or an older one?
Older one.
And he had had that vehicle for some time?
Yes.
How long do you think it was, best guess, that he had had that car?
5, 6 years.
Okay. And did you have your own car?
Yes.
What kind of car did you have?
Infinity.
Okay. When your husband would go to these stores, were you aware of whether or not he'd ever carry a firearm for protection?
Yes.
And what type of gun was that?
A Glock.
Okay. And was your husband right-handed or left-handed?
Right-handed.
Okay. And would he wear that holster on the right side?
Yes.
Now, when your husband would go back and forth between the stores, where were you living at that point in time?
And Rochester.
Is that located in the city of Rochester Hills in Oakland County, Michigan?
Yes.
And how long have you lived there at that residence?
26 years.
Because of the nature of his business, dealing with pawn and dealing with jewelry, did you have any type of safe at your residence?
No.
Nothing in it, no wall safe, no portable safe, no safe at all?
No.
Would your husband keep cash otherwise outside of the safe in a mattress or something like that at your house?
No.
Would you keep any type of valuable jewelry at your house?
No.
Did you have any jewelry that was costume jewelry?
Yes.
And where did you keep that?
In the jewelry box in my room, my bedroom.
Okay. Did you have any jewelry that was better than costume jewelry?
No.
Okay. When we get to October 10th of 2024, do you recall the events of that day and that evening?
Yes.
Okay. Were you at home that evening?
Yes.
Okay. Approximately 10 o'clock p.m. Can you tell us if anything unusual happened?
A gentleman, Hernandez, came to the front door and said that he was from DTE and needed to check for a gas leak.
Okay. Now, you identified him by name as Defendant Hernandez just now on the record. Is that correct?
Yes.
Okay. You did testify earlier at the preliminary examination back in district court December of last year?
Yes.
Okay. And you identified one of the defendants as Defendant Hernandez back then?
Yes.
Okay. Was Defendant Hernandez alone when he came to that door?
No.
Okay. Now, who was the other person that was at that door with him?
Zuazo was not at the door. He was standing on the walk.
Okay. There was a second person with him?
Yes.
Okay. Was that person, what description of nationality, ethnic background would you say that person was?
Average size, average height, black.
Okay. Where was it when you were first attention drawn to somebody being at the front door?
My Ring camera gave me a notification through my phone.
Okay. And where were you physically at in your house when you got that notification?
Upstairs by the master bedroom.
When you say you had Ring cameras around the outside of the house?
Yes.
And those Ring cameras were set up to notify you if somebody came to the door?
Yes.
And was it a Ring camera system where you could actually view on your camera what was going on those cameras?
Yes.
And you could actually see on your camera what was going on at the front door?
Yes.
Now, after you see that, do you leave your master bedroom or do you stay there?
No, I stay in the hallway by the door.
Okay, and when we talk about the hallway, are we talking about where the banister is?
Yes.
And what do you see happen as you're standing at the banister?
My husband opens the front door and asks Hernandez, could he help him?
Okay. Did you know where your husband was before he walked to the front door?
In the family room.
Okay. So what do you see happen when your husband opens the front door?
I see Hernandez standing there with a clipboard asking my husband to sign it for permission to enter the house.
Okay. Were you able to hear the discussion that Defendant Hernandez was having with your husband?
Only that he asked him to come in and check for the heat exchanger on the furnace.
Okay. Was there anything said about who they were at the door?
Just DTE workers.
Okay. Could you see any way that they were, let me just say, that Defendant Hernandez was dressed?
He was had a yellow vest on and a hat and mask.
Okay. And how would you describe his size?
Very large.
Okay. What did your husband say to them when Hernandez asked about coming inside?
Well, he asked, well, why? And Hernandez said he needed to check for a gas leak.
Okay. Did you get involved in the conversation?
Yes.
And how did you get involved with the conversation?
I asked Hernandez, I said, isn't it a little late for you to be coming to the door?
Okay. Was there any response to that?
No, he just said, I'm sorry.
All right, a bit of an issue with the feed there, so we're going to slip in our break while we get that checked. We are watching this home invasion hoax murder trial for two different defendants, two different juries, a lot of logistical movement there inside of the courtroom, but we'll have more testimony after this break.
Tonight on Closing Arguments, a family of four faces twisted allegations of caging and sexually abusing foster children. We'll bring you takeaways from today's big hearing.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
Covering the country's biggest trials before we bring you inside the courtroom. Plus, the true crime cases you want to know more about in our daily spotlight.
Opening statements with Julie Grant. Mornings at 8/7 Central on Court TV.
Welcome back to Court TV Live. We are continuing to follow this case out of Michigan. It's against two different defendants, Carlos Hernandez and Joshua Zuazo. They're both charged with murder and unlawful imprisonment in the death of pawn shop owner Hussein Murray. And we were just hearing from Murray's wife on the stand. Prosecutors say that they posed as utility workers looking for gas leaks to access the home. Then they bound the victim and his wife in duct tape before robbing them. She did survive, and he was found dead in the basement with that duct tape still around his face, hands, and feet. Let's go back in, picking it up where we left off with the wife's testimony on the stand.
Did you hear any cries out at all?
No.
Also, folks have different abilities physically as we age. How would you characterize your husband's physical abilities at his age?
Very active and strong.
He was a strong man?
Yes.
And he was still a strong man at his age?
Yes.
What's the first thing that you remember after that 10 to 15 minutes passes while the two defendants are in the basement?
I was sitting at my kitchen table, and Hernandez comes up from the basement, and I stepped towards him to see if he needed something.
And what happens then?
Then he asks me, he says, where's the jewelry and where's the money? And where's the safe? I'm sorry. And I said, I have no safe. And he says, where's the jewelry? And I said, in the bank, in the safety deposit box. And then he says, where's the money? And I said, just what's in my purse and what's in my husband's pocket.
And how much money did you have, especially remember, in your purse that day?
About $300.
Okay. And how much would your husband typically carry on him in cash?
About $5,000.
Okay. And can you tell us, after you responded that way, what happens?
Zuazo comes upstairs also. And
So he comes up behind Defendant Hernandez?
Yes, yes.
And how long would you say the delay between Defendant Hernandez coming up and Defendant Zuazo is between that?
Seconds.
Okay. Were you still talking to Defendant Hernandez about your money and your cash and your husband's cash at the time Zuazo appeared, or was that part of the conversation over?
That was over, and I asked him, where's my husband? Several times.
Okay. Are you asking Defendant Hernandez where your husband is?
I was asking both of them.
Okay. And what happens when you're asking about your husband?
Zuazo tells me that he's sleeping, and I know there's blood on his vest, and I start screaming.
Okay. And what happens as, let me ask you this, does Defendant Hernandez say anything in response after Defendant Zuazo says he's sleeping?
Not that I recall.
Okay. What's your response after you see the blood?
I was screaming, and Hernandez hits me in the face to cover my mouth.
Okay, and when you say he hits you in your face, there's a front, there's a right, and there's a left side of your face. Which side, if you can remember, he struck you?
The left.
Was it a hard or soft strike?
Hard.
Did you receive injuries from that strike?
Yes.
Did you later, after the events are over, end up going to get medical attention for the strike?
Yes.
Did you end up losing your front tooth at some point from related to the strike?
Yes.
How long was it after the strike that you ended up losing your tooth?
About a month, 3 weeks a month.
Okay. After you're struck, what happens next?
He asks me if I will stop screaming when he removes his hand from my mouth and sits me at the kitchen chair.
Okay. And what, if anything, is he saying to you at that point?
Again, he's asking me, where is the safe? Where is the jewelry? Where is the money? And I would reply the same answer.
At that point in time, where is Defendant Zuazo?
He went up the back stairs up to the master bedroom.
Okay, and you saw him go up the back stairs?
Yes.
Okay. From your recollections of that day, did Defendant Hernandez ever go upstairs?
No.
What's going on as Defendant Zuazo is upstairs? What's going on with you and Defendant Hernandez?
Hernandez was binding my hands and my ankles together.
Okay, and
Duct tape.
is that against your will?
Yes.
Okay. Did you notice if any of your items were taken that day?
Yes.
What was taken from you?
When Zuazos came downstairs, I saw that he was carrying a drawer from my jewelry box.
Okay, and that was without your consent?
Yes.
Was there anything taken from your purse that was without your consent?
Yes.
What was taken from your purse?
$300.
Okay. Were there any other items that you were missing after that day?
Well, my phone, Hernandez took my phone and put it in his pocket and took my iPhone watch and threw it across the table.
Okay. And obviously there was police involvement. Did you ever recover your husband's Glock? Was that ever recovered?
No.
While Hernandez is in the kitchen, do you see what else he's doing while he's there?
He nonchalantly goes to one of the kitchen drawers, opens it, looks at it, and shuts it.
Okay. Do you see Defendant Zuazo return?
Yes.
Okay. And after he returns, does he come down the front stairs or those back stairs again?
The back stairs.
How long were they in the house after Defendant Zuazo returns from the upstairs?
A couple of minutes because Hernandez wanted to put me in the closet, but because I was bound, I couldn't move, so he sat me back in the chair.
And what do you mean by he tried to put you in a closet?
They wanted me to, Hernandez and Zuazo wanted to put me in the closet and shut the door, I imagine.
Okay, and when you say they, I think you then specified, but what were each of those individuals doing at that point? Tell us specifically what was Hernandez doing to try to put you in a closet?
He grabbed me by the shoulder and the arm, but then I was really wobbly and he sat me down in the chair.
Okay. And can you tell me what Defendant Zuazo was doing?
He looked a little nervous and was like moving from foot to foot and asked and told Hernandez, "Let's go, bro."
Okay.
I didn't hear that quote from the co-defendant.
Ms. Murray, can you repeat, please?
Zuazo asked Hernandez, "Let's go, bro."
Okay, I'm going to show you what's been. And did they exit the house?
Yes.
How did they exit the house?
Through the garage door.
Can I have just 1 second? Did they go out the garage door, did you say?
Yes.
How long were they in the garage?
2 or 3 minutes.
Okay. And did you still have your Infinity keys?
No, Hernandez took my keys.
What do you hear coming from the garage?
I hear the door slam down, the garage door. I hear that slam.
And was any type of remote control clicker for the garage connected to your keys?
No.
Okay. How was it that you were able to free yourself from being duct taped?
Around my ankles, there was a small tab of tape that was loose, and I worked it around until it came off.
Okay. And were you able to make a phone call to the authorities since the cell phone was gone?
Yes.
And how were you able to do that?
The house phone.
Okay. And did you call 911?
Yes.
And how long would you say it was after 911 that the deputies arrived?
5 minutes. It was quick.
Okay. In that 5 minutes before the deputies arrived, did you hear anything or any sounds or noises coming from the basement?
No.
Did you go down into the basement?
No.
Okay. And to this date, you haven't seen any photos of the basement. Is that correct?
Correct.
Okay. I'm not going to show you any photos today either, but I just want to ask you just a couple things. Did your husband wear any type of rings or jewelry?
Yes.
And what kind of ring or jewelry would he wear?
He had a diamond jewelry ring on his finger and a diamond watch.
Okay, and when you say a ring on his finger, what hand was that finger attached to, right or left?
I think it was the right.
Okay, and you.
Linda Murray, such a brave witness. She lived through the unimaginable, her husband being killed inside the home where she was. We have to get to a break. Our thanks to Alexis Rosenberg for her analysis, and we have more of this trial out of Michigan coming up in just a moment. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us and following along as we cover a lot of trials here on Court TV. Right now we are in Michigan, where our newest live trial is underway. Carlos Hernandez and Joshua Zuazo are the two defendants, both charged with felony murder and 2 counts of unlawful imprisonment. And they're accused of really pulling a hoax on a family that turned deadly, posing as utility workers to gain access inside of the home of Linda and Hussein Murray. They were owners of a local pawn shop where they had a lot of jewelry. Linda was allegedly tied up with duct tape and hit by the defendants, and her husband was killed in the basement of their home. They've pleaded not guilty to these charges, and there are 2 juries that are hearing the testimony in this case. Separate ones will be making a decision on each defendant. Let's pick it up where we left off inside of this courtroom. The surviving victim, that wife, Linda Murray, she is on the stand telling everything from her perspective.
And you indicated that he had a nice watch. Was that a Rolex watch?
Yes.
Okay. Did your husband wear glasses?
No.
No glasses.
Only for reading.
For reading?
Yes.
Okay, so let me show you what's been marked as photograph 1EE. It should appear up there. Does photograph 1EE accurately depict the injury that you sustained to your face?
Yes.
I'm going to show you what's been marked as 1FF. Does 1FF show a side view of the injury that you sustained to your face?
Yes.
I'll show you what's been marked as 1GG. Does that photograph accurately depict the injury that you sustained to your wrist?
Yes.
And I'll show you what's been marked as 1HH. Does that accurately depict the injury that you sustained to your shoulder?
Yes.
Your Honor, the people would move those exhibits 1EE, 1FF, and 1GG and 1HH into evidence.
The objection?
I have no objection.
No, right there.
Once the sheriff office got involved, they went through the house that day?
Yes.
Okay, and I'm going to show you some photographs. I'm going to show you what's been marked as 1D. Okay, do you recognize that as the top of your stairs?
Yes.
Okay, you see the closet that's depicted in that photograph as open?
Yes.
Would you have left that closet open when you were in the house?
No.
I'm going to show you what's been marked as Exhibit 1F, leading into your master. Do you recognize that as your master?
Yes.
Do you recognize that chest of drawers?
Yes.
Was it left that way when you were last upstairs?
No.
I'm going to show you what's been marked as 1H. It's a different view. Can you tell us what you see in 1H?
Drawers scattered on the floor.
Okay.
And items on the floor.
Okay. I'll show you what's been marked as 1I. Can you tell us what you see in that picture?
Drawers on the floor.
And 1K?
The armoire open.
Okay. And the drawers should be inside, but they're not inside. Is that correct?
Correct.
Did you have any type of jewelry box upstairs?
Yes.
And where was that jewelry box kept?
In my closet.
Did you notice when you finally went through the house, was that jewelry box where it should have been?
No.
And can you tell us, do you recall where you found it?
It was laying on the floor in the master bedroom.
And were any of the drawers missing from there?
Yes, one.
And what was kept in that jewelry box?
Costume jewelry.
I'm going to show you what's been marked as 3BB as a boy. Do me a favor and look this way. Okay. Do you see 3BB?
Yes.
Okay. Do you recognize that?
Yes.
And how do you recognize that?
Those are my costume jewelry in my glass case.
Okay. And the Sheriff's Department later recovered these items and showed them to you?
Yes.
Did you identify those items as what was in the house before the defendants came in that day?
Yes.
I'm going to show you what's been marked as 3CC. Do you recognize that as the contents of your costume jewelry?
Yes.
I'm going to direct your attention to what's in the middle of that. It looks like some sort of award. Do you recognize that award?
Yes.
And can you tell us how you recognize that?
That was my grandfather's sports award that he got when he was young.
Okay. And that had been passed down through your family?
Yes.
I'm going to show you what's been marked as 3EE. You recognize that costume jewelry as some more of the costume jewelry?
Yes.
All of these items were taken without your consent?
Yes.
As this case has progressed, did you turn over the Ring camera video to the Sheriff's Department?
Yes.
And you had a chance to review the Ring camera videos both from the 10th and from the 11th of October?
Yes.
Did they accurately reflect what occurred and what you remember happening on those Ring camera videos?
Yes.
And you also testified to that at preliminary examination?
Yes.
Your Honor, the people would move the ring camera videos that have been designated 5C, 5D, and 5E and request to publish those.
All right, before we get to that, did you admit 3BB, 3C, that the witness just testified to? I don't see that as being admitted previously in the same.
I didn't, because the guy from Cato County is coming tomorrow, but I'll move those in today.
Okay, I mean, it's not, do it as you see fit. I just want to make sure we're not missing something. All right, so the Ring cameras are which numbers?
They got renumbered 5C, 5D, and 5E. They were all on just 5, but because of things, it got renumbered.
Okay, and then the parties have seen the Ring camera. Is there any objection to admission to it? Okay. All right, good then.
That's 5C, 5D, 5E, correct?
Yes. Permission to publish?
You may publish.
Thanks for stopping by. If you'd like to leave a message, you can do it now.
For GTE, we're trying for gas leaks. Went into the restaurant, so when she thought it was her.
Just a minute. At the front door. I don't know.
It's DTE.
DTE? That's kind of late for you guys to be coming around.
I know we've been working in the neighborhood.
DTE, I don't know, be careful.
Well, we just got a question. Have you guys had, are you Mr. Hussein Murray? Yeah. Well, gas leak? We're not. We gotta check her back. At the house for the open meter. Thank you. On the street.
Hey, what's that? Hello? No, I'm having. Yes.
And just for the record,
Well, after watching those videos, let's squeeze in a break. These jurors taking in that Ring camera footage, and you can hear the instincts of Linda Murray. She's saying that this is a strange time that you all have come around, and we don't even know the name DTE. Well, when we come back, we'll not only go back into that Michigan courtroom, but we'll keep you updated on what's happening in Tennessee. This case that we're following, where a man was already convicted, Brandon Isabelle, of throwing his 2-day-old baby in the river and killing her mother, who was his girlfriend. The jury is deciding on whether he should get a chance at parole. And that light that you're seeing there that's off right now, if it comes on, it means that the jury has a question, they want a break, or they have a verdict. So we will take you in once they reach a decision. So again, more testimony coming up in the case against Hernandez and Zuazo there in Michigan.
Tonight on Closing Arguments, a family of 4 faces twisted allegations of caging and sexually abusing foster children. We'll bring you takeaways from today's big hearing.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
4 dead students. None of it seemed to make any sense.
He was evil.
What devastation.
All I can do is scream.
Victim to Verdict with Ted Rowlands. New episode Saturday night, 8 Eastern and Pacific.
Only on Court TV.
Welcome back to Court TV Live. Let's go back in together to this Michigan courtroom that we are watching together, the home invasion hoax murder trial. 2 men stand accused of posing as utility workers and then killing the owner of a pawn shop jewelry and tying up his wife at their home. This all happened in October of last year. There are 2 juries that are going to be hearing this case, 1 for each defendant. And right now, the wife of the victim is on the stand. She's the one who survived. She was duct taped herself, and now she's talking about the aftermath of finding out that her husband was in the basement, killed.
So just, yeah, indicate for the record that was call up.
And I didn't want to bother you guys for late, but we had to check the outside. We go home. And I didn't want to bother you guys for late, but we had to check the outside.
Yeah, I understand. I understand. You want my best.
Listen, I said, how you doing today, sir? Good. I'm all right. So, you want to read? What am I paying for? Just to give us consent to check the inside of the home. So what we have to do is we have to check for like cracks in the heat.
And this next one is Exhibit 5D.
Did you go for
For
that?
the record, yes. And there's also a 5E, which is the garage video, which I didn't mention.
Any objection to 5E?
No, I've seen 5E, so I have no objection.
Okay, same. All right, then.
Come on, man. Let's keep it going.
Let me ask you just a few questions. When we were watching the video, the October 10th video, it looks like Mr. Hernandez is wearing like a N95 mask. Do you recall him wearing a mask?
Yes.
And was defendant Zazo also wearing some face covering at that time?
Yes.
Okay. On the October 11th time that they were at your house, was defendant Hernandez also wearing face covering?
Yes.
And was defendant Zuazo wearing a face covering?
Part of the time.
Okay. When you say part of the time, was there a point where that face covering gets moved?
I think when he came up the stairs from the basement, he wasn't wearing a mask.
Okay. So when he came up from the basement, defendant Zuazo's mask was not on?
Correct.
I don't have any other questions, Judge.
All right, cross-exam to Lazo.
Thank you, Your Honor. Good afternoon, Ms. Murray.
Good afternoon.
I know that you and I met back on the day of the preliminary examination, which was December 17th of last year. I'm just going to tell you the same thing that I said that day. My name is Michael McCarthy. I represent Joshua Zuazo. I have some questions to ask you here today regarding your testimony. And if I don't make one of my questions clear to you, please tell me that. Then I'll rephrase it, okay?
Okay.
I just want you to answer the questions, you know, that you understand the questions before you answer them.
Okay.
All right, thank you. Now, the event of what occurred on that day, the 11th of October, certainly nothing like that ever happened before in your lifetime, correct?
Correct.
Very traumatic, without question, correct?
Correct.
And now, almost a year has passed, and it's given you quite a bit of time to think about what occurred, correct?
Correct.
And whether you wanted to be thinking about it or not, you have this constantly on your mind, correct?
Correct.
And coming here to court again is something which, if you were able to have it fade from your memory, brought it all back to the foreground a second time, correct?
Correct.
And you're here now giving your testimony, and certainly this has been something you've been preparing for and weighing and it's been weighing heavily on you as this day, the first day of October, approached, correct?
Correct.
Okay. And in order to be able to testify, you had to sit down and speak with the attorneys representing the prosecutor's office, correct?
Correct.
You had interviews with Mr. Petrofessa and perhaps with Mr. Magaro, correct?
Correct.
And you've also spoken with a number of law enforcement officers ever since the first day that this occurred, correct?
Correct.
They came to your house. Deputy Copeland was the first man through the door at your house. You remember that, right?
Correct.
And then that was a pretty upsetting thing when you were talking with him about, you didn't even know what had happened at that point, right?
Correct.
I mean, you knew that you got tied up. There was something that happened with your property, but you didn't know where your husband was.
Correct.
And as the day wore on, things just got worse.
Correct.
And then after you were asked to step outside of the house, another deputy came along, Deputy Hagelin, and he took you to his police car so that at least you could be sitting down away from the house instead of sitting on your front porch as you were when you first encountered him, right?
Yes.
And because when you were sitting on the porch, one of the things you observed, you were sitting right there, was all the other deputies that came to your home to see what happened, right?
Yes.
And they were heavily armed, correct?
Yes.
And obviously everybody was taking what happened at your house very seriously, correct?
Yes.
All right. And so then you didn't go back into your house. Instead, you ended up going to the hospital, correct?
Yes.
And you had those pictures taken at some point during the day before you got to the hospital or before you got into a hospital bed. Is that right?
I'm not sure if it was the same day or the next day, but...
Okay. But those pictures were taken so that there would be a record of the injury you sustained, correct?
Yes.
And you spent the night, at least, of the 11th and the 12th of October in the hospital, right?
No.
No? How did that go?
I was released, and after they did CAT scan, I was released to go home.
During the time you were in the hospital, you met with another detective. Isn't that true?
Yes.
Detective Weitzman, I think his name is, or Wigeman, rather?
I assume.
Okay, but another detective came to see you while you were in the emergency room. Is that right? Okay. And then that same detective met with you some more times over the course of the next couple of days, correct?
Correct.
And those meetings were conducted at your son's home. Isn't that right?
Repeat that?
I said those meetings were conducted at your son's home. Isn't that correct?
Yes.
Okay. And so there was a lot of discussion about this incident at your house in those first few days. You would agree with that, right?
Yes.
And somewhere along the line, you learned what the name of the first person that had came to your door was, or had come to your door, rather, was Mr. Hernandez. You remember that?
Yes.
Can you tell the jury how it is you came to know what his...
Defense attorneys have to be very careful when cross-examining someone who is as sympathetic as Linda Murray here. Trial attorney Lateef Gray is with us. We've hit the pause button on that testimony. We'll pick it up once we come back from the break. But Lateef, I want to get your thoughts on what this defense is doing in the cross-exam.
Well, I agree with you about having to be gentle with certain witnesses, and it appears that that's exactly what he's doing. He's not being too aggressive, and he's not being too rough with his witness, which is a good thing.
We've got two different Ring cameras. We've got a N95 mask that at least one of the defendants is wearing the entire time. One may have taken it off at one point, and she remembers seeing his whole face. How does that complicate things, if at all? Because if it's 2 times, certainly even Hernandez's size seems to make him unique, even without the mask.
Yeah, I don't think it complicates things much because those Ring videos are very clear. You can make out who's who, so I don't think it complicates things very much at all.
And real quick, Lateef, before I let you go, the 2 juries, I've got to get your opinion on if you've seen that before, 2 separate juries, and what you think of the logistics of having different juries hear different opening statements, and we don't know how much more there's going to be a difference in terms of what they're going to hear.
I have seen this happen before, and it's very complicated because these two jurors are sitting in the same courtroom hearing evidence, and certain evidence might go only to certain defendants, and it's hard to unring certain bells. So it just complicates things. It probably would have been a lot easier to have two separate trials, but that's the way they chose to do it.
But here we are, and we know at least one of them is going to point the finger at the other one and say, I was just here for a robbery, not for a killing. Lateef, thank you for that analysis. When we come back, we're going to pick it up right where we left off with Linda Murray on the stand, telling everything from her perspective of two men barging into her house. Rather, not barging. They said they were with the utility company, so they let them in, and things turned deadly. Welcome back to Court TV Live. I'm Julia Janae. Thank you for being with us as we watch together the home invasion hoax murder trial happening in Michigan. 2 men on trial allegedly for murdering a 72-year-old pawn shop owner, Carlos Hernandez and Joshua Zuazo. They are both charged with murder and unlawful imprisonment in the death of Hussein Murray. And his wife is on the stand. She's talking about how these men that she says she could identify posed as utility workers to gain access. They duct tape her husband. He was downstairs when one of them came upstairs and told her he was, quote, sleeping, and she said she saw blood on his vest. Let's pick it up where we left off with Linda Murray, Hussein's wife, testifying.
Can you tell the jury how it is you came to know what his name was?
Police officer told me.
Okay. And then at some point, you came to know the name of Mr. Zuazo. Was that right?
Yes.
And how was it that you came to know his name?
Through a police officer.
Okay. Now, did you learn those names on the same day, or did you learn those at different times? In other words, did you learn about Mr. Hernandez's name and Mr. Zuazo's name at the same time, or were those 2 separate occasions?
At the same time.
At the same time. Do you remember when that was?
A day or 2 after.
Okay, so somewhere, this occurred on a Friday, so somewhere over that weekend or the beginning of the following week. Is that correct?
Yes.
Because while you were interacting with the detectives that were working on this case, you were giving information to them. They had questions for you, correct?
Correct.
But they were providing information to you. Isn't that correct?
I'm not exactly sure what you mean.
Well, they told you the names
Yes.
of the 2 people who were the suspects they were investigating. Isn't that correct?
Yes.
And you weren't able to provide them with those names, correct?
Correct.
You didn't know the names of either of the men that came to your home, but at some point, the detectives told you those names, correct?
Yes.
And at some point, did you become aware of the fact that Mr. Hernandez was in custody?
Yes.
Okay. And that was because the detective told you that, right?
Yes.
Okay. Now, there was some news coverage of this story. You remember that, correct? Did you pay any attention to that?
Yes.
I mean, no one can blame you for doing that. I mean, this is something that affects you in the most severe way. So it would only be natural for you to be curious about seeing what the coverage was, right?
Yes.
Okay. And when that coverage was being provided, if it was on TV or in some newspaper, there were photographs, right?
Yes.
And photographs of Mr. Hernandez, right?
Yes.
And a photograph of Mr. Zuazo, isn't that right?
Yes.
And you've been very clear in your direct testimony in identifying Mr. Zuazo, correct?
Yes.
And but you also, when you met with the detectives, you told them that this man, the second man in the house, was wearing a mask. Is that right?
When he entered, yeah.
Yes. But when did you tell the detectives that, if you did, that when the second man came upstairs, he was not wearing a mask?
In the ambulance.
In the ambulance. And when you were in the ambulance, who rode with you? Was that Detective Hagelin?
I don't remember the officer riding with me. I remember the paramedic.
You told it to a paramedic?
No, I told it to the officer.
Okay, that's what I'm asking. I just want to get clarification. The first time you told anybody that the second person didn't have a mask on when he came upstairs into your kitchen was when you were in the ambulance?
Yes.
And that you're just sitting there in the ambulance, you hadn't moved yet, and the detective was there with you, is that it?
Yes.
Okay, and you don't know that man's name that you talked to?
At the time, no.
No. And have you seen him since?
Yes.
Okay. And do you know his name now?
No.
Okay. Fair enough. But somewhere along the line, you were shown a photograph of Mr. Zuazo. Is that correct?
Days later, yes.
Okay. Now, when you were shown that photograph, were you shown one photograph or were you shown a whole bunch of photographs?
I don't recall.
Okay. Did the detective or whoever it was you were interacting with at that time, did he or she say, I'm going to show you some pictures or a picture and maybe you'll recognize this person, maybe you won't?
Yes.
Okay. Mm-hmm. And so you don't remember if you saw one picture or more than one picture, is that right?
I think it was more than one, but I'm not 100% sure.
Okay. And you made an identification?
Yes.
Okay. And then in your mind, that identification is the thing that you said, correct?
Yes.
And that is the thing that you've said consistently since the first time that you went to court and you gave testimony on the 17th of December, correct?
Correct.
And then you said the same thing today, correct?
Correct.
And you identified not only Mr. Zuazo, but also Mr. Hernandez, correct?
Yes.
So, in your statement to the police, and I think this is to Detective Wiggerman, who met with you a couple of times at the hospital and also at your son's house, you were being asked about the big man, and you were unable to provide a specific height range for him back on maybe October 12th or 13th, somewhere in there, in the days following the incident at your home. Do you remember that?
I was unable.
That's, well, I mean, that if the detective wrote that in his report, that you said that the Hispanic might have been 6 foot tall, that your husband was 6'2", and he was about as tall, and then...
I was talking about Mr. Zuazo at the time.
Okay, so you're saying that the person you were describing in the report was written down as the Hispanic man, but you're saying that you were talking about Mr. Zuazo?
Yes.
Okay, so you couldn't, and you said your husband was 6'2", and he might have been 6 foot?
Yes.
Okay. May I approach? I just want to show. Yes.
And this is from...
This is from the report that was written by Detective Wiggerman, and it's got contradictory information, and I just want to know if she can look at that, if this would refresh her memory about what she told him.
You want to come on up, first match.
Sure.
Sidebar there inside of the courtroom because the defense very gingerly is calling out this witness over her identification of his client. They were wearing masks on that ring video that was already shown to these juries. Let's get to our break. When we come back, we'll have more of the home invasion hoax murder trial there in Michigan. This cross-examination of the surviving victim, the wife who is a victim of this home invasion.
On closing arguments, a family of 4 faces twisted allegations of caging and sexually abusing foster children. We'll bring you takeaways from today's big hearing.
Closing arguments tonight at 8/7 Central, only on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight. They were killed by their own children.
That challenged the legal system and ourselves. Court TV, Legendary Trials.
Two defendants, two juries, and one surviving victim. A wife who says she saw these two men kill her husband. These two men who stand accused of killing a jeweler, they are also accused of posing as utility workers to gain access to the home of the jewelry store owner, demanding to see inside of a safe and to get jewelry and money. And Linda Murray on the stand, she says they didn't keep jewelry inside of the house. Everything she had was costume jewelry, and they didn't have any money beyond what they kept on their person. Let's go back in. The defense attorney for one of those defendants, and this is Joshua Zuazo's attorney, is doing the questioning now for the wife, Linda Murray.
Let me just get this clear. You did not describe the man, the Hispanic man, to be 6 foot tall.
Correct.
Okay. And if somebody wrote that down in their report that you said so, that person is wrong about what you told them.
Yes.
Is that right? Okay, that's fair enough. Thank you. Do you remember telling the same detective that the second man, who now you are identifying as Mr. Zuazo, had his face mostly covered?
Yes.
Okay, so which was it? Did the man have his face mostly covered, or was it uncovered at some point?
I'm gonna object. She's already clarified there's two different points in time. This is not a one-time question.
Well, let me just make that very clear. I'm not trying to imply otherwise. You've said that there was a point where Mr. Zuazo had the mask off, correct?
Yes.
Did you tell that to Detective Wegman, if you remember? And I know you might not, and that's fair. I get that. I'm just trying to make, I want to understand what your position is opposed to what it is he wrote down in this report I'm reading.
Okay, the mask wasn't completely off.
Okay, and so when he wrote down had his face mostly covered, that would be inaccurate based on what you were reporting to him.
Yes.
Judge,
okay.
Object again to the form.
You can ask questions on redirect, or it just, if we could be more specific about to whom she's talking to, because I don't know if she...
And I'll do that.
Insert that, but just making sure we know she knows who you're talking about.
It's Detective Wigman, who you might not recognize or remember exactly. I know you saw a lot of police officers, or detectives, but this is during one of those interviews that you had either in the hospital or at your son's home. It wasn't at your home. I don't know if that helps to refresh your memory.
It was in the ambulance.
Okay. Then was this individual didn't write anything down about him having the mask off at a particular time. And so if you told that to him, he didn't write it down. Is that correct? I mean, you can't explain what he did, but what I'm saying is if it isn't in there, it isn't because you didn't tell him. Is that correct?
Yes.
Okay, fair enough. And it is your testimony today that he did not have, Mr. Zuazo did not have the mask on when he came up the steps. Is that right?
We have to hit the pause button on this testimony in Michigan because we have breaking news out of Tennessee, the case against Brandon Isabelle. He's already been convicted of not only killing his girlfriend, but also throwing his 2-day-old baby into the Mississippi River. The jury was tasked with a penalty, and we understand that they now have a verdict in this second phase. There was a white light that's on the wall there inside of the courthouse, and it came on, indicating that these jurors have reached a verdict. 2 hours and 30 minutes they've been at it, and they were told that they had to make a decision on whether or not he qualified for parole. We're seeing that movement already inside of the courtroom. Not sure yet if the jury is inside. We'll see if they rise, but let's listen to what the judge says.
Kind enough to prepare the order for pre-sentence report, and I think we You may be seated. It is my understanding that a decision has been reached. Yes?
That's correct.
And is it unanimous?
Yes.
And all signatures are affixed to the document?
Yes.
If you'll please provide that document to Deputy Moore. Thank you. I told you when this started that I needed you to do this job. Thank you. You may be excused.
Jurors excused. Like to step.
Mr. Isabelle, according to the documents provided by the foreperson of this jury, we, the jury, unanimously find that the state has proven the following: aggravating circumstance or circumstances beyond a reasonable doubt. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. You will return to this court on October 31st for the status report on the remaining charges. As to count 2, life imprisonment. As to count 1 was an automatic life sentence. And we'll pick up on counts 4 and 5, the aggravated child abuse and the especially aggravated kidnapping, on November 12th for a sentencing hearing after receiving this pre-sentence report. Thank you. We are adjourned.
All rise. This court is now adjourned to 9 a.m. tomorrow morning.
Welcome back to Court TV Live. I'm Judge Ashley Wilcott, honored to be with you today. We are tracking several major trials here at Court TV. First in Florida, a jury found former Deputy Leslie Boileau guilty of manslaughter today after he took the stand admitting that he aimed his gun